Okay, great. So we're recording. We're live. Thanks everyone for jumping on for the vCISO News monthly series. I actually think we skipped January, so not quite monthly. But you know, as a lot of you who are attendees here, is not your, in many cases, not your first time. These series are great. And we've had some really great topics from some excellent speakers. And just to give a quick background on vCISO News and what it is that we're trying to do, myself and Loredana Nikolai, who's on the phone as well, we've worked together for quite some time. She runs a marketing organization that supports our company, Symbol Security. And from the beginning of Symbol Security's inception in 2018, I personally have been really impressed and fascinated with the vCISO community and the people I've met that serve as security consultants and executive consultants to organizations, helping them really to navigate some of the most difficult challenges. And what we noticed was there wasn't really a good set of community and centralized information and best practices for these vCISOs and these security consultants. And so Loredana and I said, hey, we think we can provide, you know, some help for this community. We think we can provide some exposure, and we think there's value in the networking. And we've definitely been right on at least a few of those. And you know, we're working on growing the structure and getting this to be more regular. But what has resulted from that is trying to put together some relevant topics on a monthly basis, bringing in expert speakers and having a good discussion, a good frank discussion about some really critical issues, including growing vCISO practices, how you grow them, things you should consider as you're delivering services. And for our topic today, you know, I think it's a great topic, discussing the potential for legal liability in vCISO engagements. And so I'd like to introduce Steven Teppler. Steve and I go back quite a bit. He has provided services and counsel for Symbol Security, and you know, he's been a good friend as well. And he's one of the most intelligent people I know in this space. So Steve, I think I'll turn it over to you just to give a quick introduction of yourself, and then, you know, we can jump into the content and we can jump into the discussion.
Thanks, Craig, and the check is in the mail. I chair the Privacy and Cybersecurity Group at Sterlington PLLC. I'm of counsel, same idea at Mandelbaum Barrett, and I think we're hearing some.
Yeah, I'll try and mute that.
Yeah. Anyway, my practice involves cybersecurity and privacy, and it's been a busy year.
Absolutely, I can only imagine. Well, it's great. Thanks, Stephen. Thanks for jumping on. The topics that we touched on as a community in December, and this was Mike Morano delivered a bit on what vCISOs were dealing with around. And Mike, I'm going to ask you to just step in for a moment. He may have stepped away, but you know, there is a responsibility that, you know, all companies are required to provide around certification of, you know, the cybersecurity expert in the organization. I believe it's qualified individual was the term. If I'm off there, somebody please let me know. And it brought to light some questions about the responsibilities that the virtual CISOs and security consultants bear when they take on work on behalf of an organization, and then are represented as, you know, as the expert and as the one, you know, making the decisions that could potentially, you know, be a line of responsibility to you know, negative outcomes in the case of breach or other incidents. And so the question came, you know, how can the community, you know, do their job and properly protect themselves? And I thought it was a fascinating topic, and Steve, I think it'd be a great one for you to hit on, And for all of you that are out there, because we don't have a huge audience today, we have a good sized number. I think it's a good topic to discuss fairly openly. So if people want to come off mute, ask questions in the middle of the conversation, no problem at all. We don't have to save them to the end. And you're welcome to pop some questions into the chat as well. So between Laura, Dana, and myself, we'll keep an eye on the chat if there's questions that come up. But for us for today, the topics that I figured we would hit are vCISO consultants legally exposed. That's obviously a broad topic. How does qualified individual tie in to this concept? And are there engagement and or contracting agreement best practices that vCISOs should consider as they engage with clients in an effort to provide the right amount of protection for themselves? So that's the content for today and the topics I think we cover in conversation. And so Steven, I'll ask you to kick it off. And as we work through some of the content, I encourage all of you out there to just ask questions. We can keep this free flowing. We've got almost 50 minutes here. So we have plenty of time to cover a lot of ground.
Greg, I'd just like to add that, Mike did a great job last month or whatever. And Steven, just so you know, the topic came from a question that I asked Michael in that I was working for, and the names have been changed to protect the guilty client. And what happened was, as we were doing our cyber risk assessment, we discovered that they had an employee that basically sent, I'd say, several hundred usernames, passwords, IDs, account numbers of financial service industry, with the accounting numbers, the routing numbers, social security, everything that you need to pretty much take over somebody's identity. And I brought this to the CEO's attention, and they said they would take care of it, but they never got back to me on whether they took care of it. And I got the impression that they didn't take care of it. And so I asked Michael point blank, what do you do in a situation like that? And Michael, I think he had to jump off, but Michael's basically, I'm talking about Mike Morano. He basically said, at that point, that's a client you don't want.
Right. Yeah. Makes sense.
I have to unmute myself because on occasion I have a dog that decides that he wants to add his opinion into the mix. No, Michael, you're absolutely right. As a lawyer, we are there for our clients. Our number one concern for confidentiality and competence and all this other stuff. But the flip side of that is that they are also perhaps your most dangerous adversary. Okay. And you have to keep in mind that you step over the line or you fail to do something, or the other side perceives that you failed to do something, that relationship can turn upside down really quickly. So what the problem that you just described, Michael, is not unusual. And the idea is how do you protect yourself against this? Hold on one second. Don't go away. I'm going to quiet down a dog.
Yep.
I think the dog's upset. It's probably my voice that's setting him off.
Nope. I feel you, Steven. I have the same situation at home.
Oh, okay.
All right. I'm back. The dog is with me. For those of you who can see, Lulu is going to be participating silently.
Okay. That's all he wanted was some attention. Just wanted attention.
So the idea is, how do you write? What do you do in terms of writing up your SOWs, your MSAs, to protect what you're doing in the event that your client decides not to do something? The basic understanding is that, hey, there's a difference between risk avoidance and risk ignorance, right? Evading a risk is not the same thing as mitigating it or avoiding it or instituting a control for it. So in your agreements, there should be some provision where if you provide the client with advice and they do not follow it, then you absolutely disclaim any liability for any ensuing problems it might have. That sounds like a logical thing to do, but you're the expert, you're coming in and they're going to inevitably say, you never told me about this, because sometimes, memories can be faulty by design or by inadvertence. And so number one, you have to protect yourself from protect yourself at the outset in your agreement language. And number two, what you may want to do also is do the usual CYA, write a memo, put it in writing to the CEO and say, look, we have, and you can be gentle about it. You can say, we have demonstrated, or we have explained to you that this is the problem. Your risk is this, there's a vulnerability. What's the risk in continuing on as you are? You have advised me that you are tabling addressing this for the moment.
And that's what I did.
Something
Stephen.
like that.
That's what, no, Stephen, that's exactly what I did. I wasn't as articulate or as nice as you were, but I basically, I did CEO, the COO, and the CFO. And I have 19 emails that document my involvement, my recommendations, their responses, and then what you just said. My sister's what they call in Boston a triple eagle: BC High, Boston College, BC Law.
Wow.
And so, yeah, she's my little sister. I'm not jealous. I'm not bitter. And so she revised my contract just like you just as you described, Stephen.
Good. And that gives you, look, no level of protection is bulletproof, but certainly this is about as strong as you can get. So she did the right thing.
Yeah, and she has a copy of all the emails.
Excellent. And again, yeah, keep good records. Yep. Look, as vCISOs, you have two channels of communication. One channel is we only speak about X by phone, right? Or on some other protected means, because you want to protect perhaps, and you want maybe a lawyer in with you so you can protect attorney-client privilege if this is pre-incident. But for the other more, for the stuff that protects you, you have to keep it, you have to put it down and keep a record of it. And even if you have to produce, we just did a tabletop for a large law firm in which the report was generated by the cyber forensics people and sent to me an encrypted USB, which I then drove down to the client to hand to their CISO, because I really didn't even trust it going through FedEx's channels. So, you'll know what to do and when to do it, but definitely keep your records good.
Okay.
Steve, you touched on something I think that's worth reiterating too, which is the decision between written communication and verbal.
Yeah, you want verbal communications. Look, language can be misinterpreted. All right, I'm not talking about hiding anything, about doing anything fraudulent, but if you find something that, say on a threat level, vulnerability level, ranges, is a 2 out of 5 or 2.5 out of 5. All right, not necessarily the most, the most emergent thing you can think of in terms of addressing, right? Maybe not the most direct, immediately addressable. But if that winds up being being sought after in litigation, right, and you don't have an attorney who's been involved in that as kind of a protector for the information as attorney-client privilege communications, that may be discoverable in later litigation. So, and that's not bulletproof either, but certain things, for the definitive statements you want them on the record. For your speculation or your investigatory dynamics, perhaps you want to keep them oral. And remember, to protect you, put down what you need to protect in writing to protect yourself. Also, remember, you're protecting your client as well by doing that. You'll know, again, you'll know when that line gets crossed and the client says, I don't want to deal with this. That's different.
And that's the very important point, Steven, is when the client crosses the line, because that's really what this is about. You know, as vCISOs, everybody here understands, and you know when the client crosses the line, because you get that feeling in your stomach, and you know you don't feel comfortable with what's going on right now, and that's that. Then you know the client's crossed the line.
So I have a question for all of you too. Then you know, just doesn't need to be answered directly, but just for discussion. So it would seem to me a natural, you know, reality of being a third party is that if something goes wrong, or if there's, you know, a claim brought on the organization, on the company, you know, that's of a cyber nature, it might be a natural reflex to try to redirect that, you know, that incident, that blame, and that liability over to, you know, the vCISO.
Typically, that's the person who gets thrown under the truck, whether you're virtual or on-prem, you know,
Right.
However on-prem you might act as for the company. Pardon me. What we, you know, when I come in for one of my representation engagement in a cyber risk assessment, my job is to help, and you know, your CISO or your vCISO keep their job. You know, the idea is not to position the CISO as someone who gets thrown under the truck as soon as something happens, because inevitably, you know, anecdotally, I will say that you know, they're the easiest target to say, okay, we fired this person and we're rehiring someone else, and that makes it all better. That's our Band-Aid, and that's typically what I've seen happen. And my job, part of my job, is to create an ally in the vCISO so that they know that we're working for common goals. You know, protect the client, protect the vCISO as he or she winds up doing what they do.
Great. We got a question in the chat, which I think is one of the one of the things that's on my mind too, which is from Mike Morano, says, what type of language can we add to our agreements to reduce liability? Is our client responsibility section enough? So Mike, you want to expand on that? I'm assuming in the client responsibility section, you're doling out, you know, the responsibilities of the client that would make it clear that that's not your individual or your entity's responsibility, it's client's responsibilities. And what you're asking is that enough?
My sister put in about a paragraph of legalese, Stephen. It's kind of like acronyms when I talk to non-technical people, but she put in about a paragraph of legalese, Craig and Stephen, that basically resolved me of the liability if I tell you that this needs to be reported and why it needs to be reported. And I follow the regulatory procedures of whatever state, local, or regional or because I have, or country, because I have some overseas clients as well. And it was about a paragraph, maybe a paragraph and a half that she put into my contract.
One other point, and that's a great point that you raised, Michael, is that you want to have affirmative disclaimers of liability.
Yes.
You know, you hereby, you know, the vCISO's liability, you know, you may limit it to gross negligence or intentional acts, or you disclaim any negligence or gross negligence acts, or you might say, you know, well, first of all, in your SOWs and your MSAs, you have to be crystal clear that your, to the extent there's any liability at all, it just arises from the work that was done. And to the extent that that advice was followed and implemented, you know, was not implemented rather, then you disclaim any liability for what might ensue. But the idea is you just want a general disclaimer that, you know, you you say that you use best practices, industry standard, however you want to use it. But again, you're aside from that language, having that advising the client as to what they need to do and getting an affirmative, we're not going to do something, is probably equally important. I think both of them have, they're both take care of both ends of the spectrum. One thing about making sure that your client does, make sure your client responds, right? To say, please advise. And if the client doesn't say anything or flumpers around, that's giving the client cover to dissemble in the event something happens. So, follow up. And as Michael said, you send 8 emails or what have you, and say, we received no response from you. We assume that you do not want to take any action at this time.
And she actually, to answer Michael's question that he put in, I would say, no, the client responsibility section is not enough. She created another section, and I don't remember the exact legalese, but something to the terms of disavowalment of liability of good cybersecurity.
The limitation of liability.
There it is.
Yeah, and the limitation of liability that I see or have drawn up, depending upon who I represent. I'm sorry for interrupting you, Michael. Is basically the maximum amount of my liability will be the fees that you paid me.
No, thank you. That was perfect, because that's exactly what it was. Limitation of liability. Thank you, Steve.
And what you want to do, of course, is you want to add an arbitration agreement, because that usually favors the service provider. Number one, it makes it less likely that the client will try to hang you by drowning you in legal costs, because arbitration is typically quicker and cheaper. It also it takes some of the sting out. Also, you want to have. I'm sure that your sister included a jury trial waiver.
He did, and she actually did the arbitration as well. My uncle used to do the baseball arbitrations. He's a UCLA law, so she has the arbitration. She has the jury. She did her job. I owe her money.
Did she include a class arbitration, a class waiver, and a class arb waiver?
I'd have to pull it up, but I thought I saw something about class action or something like that. So
the idea is not that your client necessarily would sue you on a class basis, but look, if you have 1,000 clients, you have this, and you did the same thing to 1,000 clients, arguably there could be one. But your clients.
Absolutely, and that's
your client is an MSP and has 1,000, 10,000 clients, and they get affected by something that your client says you failed to do.
This was a financial firm, so that what you just described would be even more egregious.
Oh yeah, that'll put you out of business, without a doubt. I mean, to even start to gin up a response to a class action lawsuit, and I've done a number of them on both sides of the V, both plaintiff and defense. A couple $100,000 just to be able to start the ball rolling with your lawyers, and with the investigation that you'll have to do to assess how you're going to address the complaint itself.
Absolutely, and
not fun. So include all that stuff in your agreements. It's really important. You want to have cyber insurance. You definitely want to have cyber. Yeah, it's expensive, but it's much. Hey, I have insurance. I'm in Florida. I have flood insurance. Guess what? Have I ever been flooded? No. But the day I cancel my flood insurance, I know what's going to happen. So if there is a likelihood, and we're in very, very, very sensitive positions here, and people make mistakes. Everybody makes mistakes. And so you really want to protect against that. Try to negotiate the cheapest retention that you can. But remember also that in obtaining cyber insurance, you're going to have to eat your own dog food and show that you have that you've checked the items and can demonstrate the items that you're checking in terms of your internal security processes and policies.
Couldn't agree more, Stephen. And luckily I was, working for BizLock, but for everybody else, I'll put it in the chat, the company that I recommend, for vCISOs. It's called HISCOX or HICOX. I'll put it in the chat.
I think it's HICOX, HICOX.
Yes, HISCOX. Yes.
HISCOX. Yeah.
Yeah, HISCOX. I will put them. I will put that link in the chat for everybody because I recommend them on a vCISO level, and they're reasonable enough right now because that's who I'm recommending to clients now. Because even when I go to BizLock and AIG pulled out, they have special rates for smaller organizations. And I think based on my experience, and I've been underwriting, cyber insurance, they used to give you $250,000 for free. And then anything over that, I would come in and do an underwriting. Now, if you want $6,000, they want me to come in and do an underwriting. And basically that's a cyber risk assessment. And I'm not kidding, $6,000 worth of cyber insurance. They want you to actually come in and do a cyber risk assessment for $6,000. I mean, it's easier to insure a car now than it is to get cyber insurance.
Oh, and then speaking about cyber insurance, you got to be careful about your policy, about your policy coverage, right? There's been, two things happened in the past. One to one of my clients, and one to two very large publicly traded companies. I'll start with those. Merck and Mondelez both were hit with ransomware. Mondelez is a big candy snack company headquartered in Illinois, and Merck, as you know, is the pharmaceutical company. Both hit with ransomware. Merck's system almost shut down completely. My sister worked for Merck. She recently retired, but she told me that they were down for like almost a year, and it took them a year to recover. And I think it cost them like $800 or $900 million. Mondelez, and she was lucky because she wasn't connected to the internet at the time, so her laptop and her research was readily accessible. Mondelez, I believe, had something around, if I'm not mistaken, 18,000 workstations and 7,000 servers basically locked up. So Mondelez and Merck both claimed against their insurance company. Mondelez claimed against Zurich. Zurich they made a claim for 800 million or 900 million, something like that. Merck's and Mondelez were somewhat similar. And Zurich came back with 100 million counter. Mondelez said, no, we really have all these losses. And then Zurich said, well, tell you what we're going to do. We're going to deny coverage because it appears that this was a North Korean APT, and since it was a terrorist, this is excluded under war and terrorism. Zurich and Mondelez have been involved in some litigation for, I think, 2 or 3 years now. Merck recently won its case against like 5 or 6 insurers. Pardon me, coffee went down the wrong way. So Merck recently won its verdict for about $800 or $900 million. But you have to look at what the terms of your policy provide. And for one of my clients, there was a requirement, I've never seen this before, that in order to claim for a cyber incident, you had to have detected it and reported it beforehand. It's like potholes, right? You can't sue for falling in a pothole unless you report it first. This is true.
I believe it. That's just, it's amazing.
And suing an insurance company involves money. But this client decided not to. I basically thought it was egregious enough for a bad faith claim. But these things you have to look at. And vCISOs, I think, especially have to be sensitive to this.
Great. Thanks, Steven. Super interesting discussion and good dovetail into cyber insurance as well. One of the things I wanted to cover here as well, which came up the other month and we heard reference to, was the concept of qualified individual. And obviously, as vCISOs, you're in an engagement with a client. There's terms and conditions around that engagement. Does the severity or the I guess, the culpability change if you're also a qualified individual on any of these representations, as it reflects to industry compliance or any of the cyber requirements that require qualified individual? Does that change the game in terms of liability or potential liability?
Who's requesting the qualified? Who's requesting a qualified individual? Is it the client?
I believe the client has to name one.
Okay, so it's the client's qualified individual, not
Which,
the
help me
Yeah,
out, guys,
yeah,
in
it's
some
not-
cases that becomes the vCISO.
Yes, it's kind of like the CFO. If you're a FINRA regulated company, you have to have not just your own CFO, but you also have to have a qualified individual that kind of double checks your books.
Okay.
It kind of put the vCISO in that role, Stephen, in that, when that's the role they put us in.
My guess is that it's a matter of designation. Am I correct?
Yes, because not all companies and clients will do that, but some will. Absolutely.
And if that's the case, is that something for which you have to charge more or require a greater in-depth knowledge of what your work for the client involves?
Yes, to both questions.
Yeah,
Yes.
as soon as somebody makes
Absolutely.
creates a representation of greater capability,
Absolutely.
there's a greater duty that ties into that. And so, accepting, it's like making a certification versus a representation. You certify something, you're basically almost guaranteeing it. Representing something is that, to the best of my knowledge. And there's a semi truckload worth of space between those two.
Yeah, and the big one for the certified is the CMMC. So we're working with the Michigan Economic Development Commission. They received $1.2 billion, and they're trying to help small businesses get CMMC certified. And so, in order for us to do that, we have to certify. And you're right. It's what you call it, a truckload. It's
a semi.
Semi. It's a couple of semis between, that's what I'm going to say. It's a couple of semis, especially for the CMMC. They just came out with version 2.0, and I won't bore you with all the details, but yeah, it's two semis.
So I believe that this qualified individual, Michael Morano, don't you have to provide an annual report to the board of directors, a governing body, with the overall status of the cybersecurity program? And if that's the case, combine that with New York's new Shield Act, and you have a whole, what are you inheriting when you get designated as a vCISO? In the end, are you a contractor, or are you someone directly in line with management for potential liability for a cyber incident, or for a failure to report, or for a regulatory deficiency?
Great question. Hey, everybody. Sorry. Of course, there was an inconvenient call at the same time as our kickoff, but I've been here listening with at least one ear. And what Steven just touched on too is something that comes up in NYDFS and now the FTC. In the case of NYDFS, the client, we're basically attesting to the report that they file April of every year, coming up shortly, and that we're overseeing the program. We're that qualified individual. So call it like the fact checker, the sanity checker of everything that they're filing. That is where we sign the dotted line that is being done. So there is I believe there's a great deal of liability there, and that is something that we should be prepared for. And that's what I mentioned a little bit earlier in the chat, where client responsibility. What I've done recently is, in terms of client responsibilities, the client is making sure and assuring that they're doing all of the things that are required. Like if there's a pen test requirement, in the case of NYDFS, there's 2 vulnerability scans per year minimum that the client is going to do those things, right? If it's outside of the scope of the virtual CISO. So in terms of, reducing that liability and having clearly defined client responsibilities, those are the types of things we need to do. Steven, you're on mute.
Dog again. Whose responsibility is it to advise the CFO, the CEO, or the COO of the semi-annual pen test requirement? Is it the vCISO? Is it the attorney? I mean, who basically says, "Hey, we got to do X"?
So at this point in time, you take NYDFS, it's been around for, let's say, this will be the second, third year companies will be performing that annual reporting. So typically there's a program in place. And like, I'll give you a great example. We have an opportunity to step in. Recent CISO left the organization. We have an opportunity to step in to be the fractional vCISO, right? To be that qualified individual now for a firm. And there's an assumption that last year, everything was done. And the company has stated that they're doing these things and everything was done and they passed last year, right? There were no issues. There's an assumption that everything's being done. And we go through a health check to make sure that at a very high level, check the box. Did you do the pen test? Did you do the vulnerability scan? Did you do the training? Like all the things that are clearly defined in lines 1 through 20 of NYDFS. But it's what do they call the honor system? We're not actually
aspirational. It's not aspirational. It is, but it is an honor system. You're presumed to be honest in what you are representing on pain of being called out for making a misrepresentation. But you're heading in a direction I wanted to talk about, and that is parts of this is interpreting law, right? It's if you look at the New York Shield Act, what does it require? It requires technical, administrative, and physical controls, right? Or physical considerations to be made. Who makes that determination and who goes over that? Is it your chief operating officer? We're talking client now. And, no, because the chief operating officer, is that really where the COO's focus is, or most of the time should be? CEO, certainly not. What we're looking at now is similar to a virtual CISO, is your cyber legal C-suite or near C-suite officer.
Well, they have a chief compliance officer role, Steven, that I've seen take that.
Yeah, but compliance and security, they don't mix real well.
Well, I disagree with that, but go ahead. I respectfully disagree with that.
I'm the bad news person for a client. I'm internally the bad news person. Say, you've got this problem, you've got to do this. I've come in, compliance officers are not necessarily, they're not necessarily so steeped in either security or privacy issues that from a legal perspective.
I agree completely with that. I agree completely.
That's what I'm saying.
They're usually lawyers, but to your point, I agree with that last statement 100%. So that I'm just the recent engagement. That's what I did. I worked with the chief compliance officer, and we went over similar to something that Mike mentioned. It was a different state, but the same kind of regulation. It was actually Massachusetts, and they have some new laws in Massachusetts around data privacy and some other things. And basically, it was us, a 6-hour meeting going through all these regulations, and her asking me, "What does this really mean?"
Yeah. So what do you say if you have both? We operate in a world of policies, right? Policies and plans. So you'll have both technical plans and administrative plans, right? The two have to meld together. The two have to operate in conformance with each other. Otherwise, you're going to have a Keystone Cop situation in the event of an incident. So is that a compliance officer's role, or is that more of You know, what I'm looking at are attorneys who have their feet both in the legal and in the cybersecurity areas, so that you can have both sides talk to each other.
Yes, and that's I think that's the part of the vCISO's job is to help facilitate that. So a lot of times,
and working with legal to do that.
yes,
I mean,
exactly.
Yeah,
Exactly. So I think that's part of the vCISO's job is to facilitate that coordination, that communication, and even translation, if you know what I'm saying.
Oh yeah, absolutely. You know, and lawyers will rely on the vCISO to do that. And so what you're basically doing is providing a little bit of attorney-client protection. You're also providing the insight from the legal side of, okay, you say you're doing this. vCISO says, yes, we are doing this. We're looking at the policy. The policy says do this. Does the plan conform to the policy? When have we updated it? Are we missing a policy? Are we missing anything? And what can we represent to a regulator? What can we represent to a customer? What can we represent to an insurer at this point that's accurate? Easy, right?
But yeah, no, I agree. I didn't mean to be a troublemaker, Craig. I respectfully disagree with Steven. It's just that, from a cybersecurity, compliance and cybersecurity are very interrelated in an organization that's well run. Let me rephrase that. Okay.
I will concede the point to you.
I like you, Steven.
I'm going to focus on well run. Okay.
Yes, I said well run. I did put that adjective in there.
Yeah.
So just in keeping on track, did we cover to everybody's satisfaction the concept of qualified individual, whether or not it adds additional liability, or whether there's any strategies to address that? And I think what I heard was you better be charging
liability to the
premium
CISO, to the vCISO.
Yeah, go ahead. Repeat that, Steven. I'm sorry.
It will add potential liability to the vCISO. Be very careful. Either charge more or don't do it, or don't be one.
Yeah. Okay, that's fair. Steven, you and I had spoken in other frames of reference about the concept of attorney-client privilege and where that may be beneficial in some correspondences. It was a different topic, but I think it's an interesting concept. Probably maybe a concept where if we look at a vCISO and where they might start to smell trouble, what can attorney-client privilege mean, and when is it critical, or when is it important?
It will be. You're directing this to me, Craig?
Yeah.
It's a tool. It's not perfect. It's not totally bulletproof. So let me preface that with that qualification. But for pre-incident activities, it can help shield the laundry being cleaned sufficient to shield some of that information from prying eyes. Maybe not a regulator, but certainly from, I'm talking about civil liability, class action. It is what it also does is it helps. It helps. Let's put it that way. I don't want to overstate. I don't want to understate.
No, that's fair. And really the scenarios I can see for all the vCISOs that are with us today are you see there's a potential issue that's starting to emerge. Hasn't been fully defined yet. You haven't confirmed 100% that we have a problem, but we may. And either that problem might, come back to you personally, or it may just be, in looking out for the organization that you're serving. And at that point, where might it make sense to engage, in attorney-client privilege to protect, before things get, potentially damaging.
Give you one more example of that. there's a difference between a suspected incident and an incident. In some measure, based upon the facts that are presented by the vCISO, the question as to whether or not something becomes a reportable incident is gray. And guess what? The attorney can help with the decision upon which the client and the vCISO can rely that this is not, this doesn't pass the smell test to trigger a reporting requirement. And that's happened on numerous occasions where, there was, there was something that was really exposed, but nothing ever happened, all right? Or let's say there was an exposure of credit cards, right, of payment cards. And it's on a server that basically is, could have been, was publicly facing or publicly accessible if you searched around a little bit, but all the credit card information on there is 7 years old, right? Everything is expired. Nobody has reported, none of your customers have ever reported to you that there has been any kind of compromise or incident with relation to that card, okay? Tell me, what would be, what's a lawyer going to advise? I mean, perhaps it doesn't rise to the effect, it rises to the level of a reportable incident. Why? Because there was nothing ever happened. From a potential liability perspective, it's a non-event. It could be deemed to be non-event. That makes sense?
Yeah,
I mean,
no, it does. And I just wanted to open up the topic too, to see if any of the team members out there had any questions around that concept of, when attorney-client privilege might be beneficial in the discussion of anything that they come across.
I have something to say.
I've seen that one come up a lot too. Go ahead, Michael.
Oh, thank you, Michael. So one of the things that we do, and Michael Morano, I'd like your input on this too, is, when there's an incident, and I mean, you verified that there's an incident, and, we build CSIRT teams, which are cybersecurity incident response teams for you, Steven, if you didn't know that. I don't mean to sound condescending, but that includes everybody. And one of the things that we tell them is that, well, who should we call first? I said, well, if you call the FBI, they might seize your servers, and that's even worse than ransomware. So you should call first your lawyer, your legal counsel. And that's what I'm telling my clients. What do you think, Steven and Michael?
Michael, go ahead, and then I'll give my thoughts on that.
What I was going to bring up before I answer Michael's question is, in many cases, the clients want any type of reporting or any type of evidence actually provided to their legal counsel first, just for that privilege, and the idea that hopefully it would remain confidential through the client attorney privilege. And if we were to send it to them directly, it would be discoverable. And I mean this in the area of very regulated organizations, SEC, FINRA, where they're doing email retention for many, many years, and all of that stuff would be discoverable during a regulatory exam or potentially some type of audit. So that's where I see that come up a lot. And regarding what Michael was just saying in terms of who to call, ideally there's a playbook set up beforehand, right? Your incident response plan. Maybe this was Steven's thinking as well with the head nod, that we already go through these exercises, ideally in tabletop exercises. We already have playbooks. The GC, the general counsel, your lawyers, your legal team, they're the first to be alerted once you realize there is an event. The one thing I want to throw in there too, the SEC just published last week, their new requirements, and within them they describe what they consider an incident, right? Because semantics, it changes a little bit everywhere. So if we have time, let's talk about that. Steven, I'll hand you the baton.
Okay.
answer Michael's
and I
question.
agree. I agree that latter comment, that latter subject we should touch upon. It is, you should first, there should be a playbook, but the first thing you don't do is call marketing and say, how are we going to announce this? And I've seen that happen with large clients, and without a playbook. And you want, but your counsel has to be aware of what counsel has to do, right? And counsel then has to weigh, do we talk to, do we call our insurance first? Do we call cyber folks to come in and do a forensic analysis? Are we required to report to law enforcement in any way? There has to be a couple of things going on at the same time. There's some juggling of contemporaneous activities that likely will have to happen. Right. So I totally agree on that. And what was your second point that you wanted to go into?
So what I was mentioning was the SEC just published their latest requirements. Within them, it talks about, and what it talks about is how quickly, and I believe it's like 72 hours now, how quickly you need to report an incident. And they define an incident now as something that impacts the operations of the business, right? Because we know, like, all day long we're getting phished. There's always somebody clicking something. But if it's not an impact to the operations of the business, it's not a reportable event, right? According to this definition. But I imagine this is going to be something that's going to be debated, and we're going to hear a lot about over the next couple of weeks. I already see lots of Cliff Note versions of the reports that have been published. The original document was like 300 pages. But I was curious what you thought about that.
You hear, you have state breach notification laws out there as well.
Yep.
And in Florida has one of the most strict breach notification laws, and they include intrusion or an access to the definition of incident, reportable incident. So tread very carefully on what you look at as reportable or not reportable, which is also why you want to do that initial assessment to see, well, has there really been an intrusion? Can we call this, is a ping an intrusion, or was there truly someone coming inside the firewall? And even if they didn't do anything, right? So just be careful out there. And you may be subject to different standards from different states, regulatory authorities, or common law even, or statutes.
That's a great point. I just dropped in the chat message one of the quotes from one of the articles that gives a little more color. And I actually read recently too, I think it was Massachusetts that led the US in terms of reported data breaches, somewhere in the range of like 2,500, because their threshold is so low. Like literally,
yes, Michael, yes.
five people
yes,
are hacked, like they got to report it.
Yes.
So I know that's your town, right? That's your neck of the woods. So
yes, it is.
So and it's important, in the end, it's important for you to have competent professionals, both on the technical and legal side, to be able to say, no, you don't have a problem.
Yeah. Because
there are times that you don't. Suspected does not mean actual, and really, good evaluations can really be very valuable in making that assessment.
I also think like the 72-hour reporting time frame, it might take a few days just to get all of the ducks in line to understand there has been an event or an incident. So that compliance requirement does seem a little unreasonable in some cases.
Isn't there a carve out for I'm sorry, I'm getting another ping for 12 o'clock. Isn't there a carve out for investigation?
I don't recall, but again, like this is all new. new information. And I imagine over the next couple of days and weeks, there's going to be a lot of webinars, roundtables, and lots of conversations about it. So keep reading and learning and sharing that knowledge.
Yeah, great. So Steven, I think you do have to jump, and I'm sure many of you have to jump at the top of the hour. I think we covered a lot of ground today. This was really great. Was there anything, I guess, any parting words anybody wanted to see? I'll give you Steven, I give you the floor here for a couple minutes just to close out. And I do want you to reiterate where, where people can find you, and I'll get your contact information out to everybody that's signed up as well. But anything in closing that you'd like to add?
Things are getting more difficult than easier. Criminals are always one step ahead because that's the way the world works. We're always playing catch up. We have to be cognizant of the fact that we have to keep vigilant, and our clients have to keep vigilant. This is not anywhere near an ROI analysis. This is always about 12 doors and 11 locks and not being almost secure or almost compliant. So that's pretty much the way I've been looking at it these days. And nothing's perfect. So, your best efforts will help you more than ignoring.
Agreed. Thank you, Steven, for your time. I'll get your information out to everybody. For those that want to stick on a few more minutes, we can wrap up. If you have to drop, please go ahead and drop. We're going to record the session. We'll make it available. I think there's more left on this topic, quite honestly. And I think it's going to evolve for all of you, because we probably haven't seen the impact of some potential lawsuits and of some conflicts regarding the role of the vCISO and any incidents that companies have, and if they try to associate or place blame or liability on the vCISO and how those situations play out. I think it was great advice from Steven to make sure that liability is something that you cover and resolve yourself of in the agreement itself, in addition to the highlighting of customer responsibilities and what they need to do. And I think situation by situation, there may be some unique differences based on the type of engagement that you have, and then the type of client that you have that may require additional things to consider. So I don't know how you all feel. I think we should probably keep a close eye on this topic in general, and Steve, maybe we'll be reaching back out to you in the future and potentially.
Happy to do so. Thanks for inviting me. It's good talking with all of you, Michael and Matt, and everybody who's participated. Thanks very much.
Great job, Steven. Great job.
All right. Take care and be well, everybody. Be careful out there.
Thanks, Steven.
Thanks, Jerry.
For those that are staying on